and we're talking about budgets right now. So I met this morning with Senator Kitchell and Stephanie Barrett, and Stephanie's not able to join us. I will tell you that it's been our combined recommendation to the full Appropriations Committee that when we're looking at the requests of the Defender General, the state's attorneys, and others, that we do 2 years of funding and not 3.5 or 2.5, whatever they requested, because there will be money set aside, and this is speculation at this point. And I believe that one of the there's obviously some things that'll drop in or drop out at the when the Appropriations Committee works on it. But I have to be honest in that I had in the state's attorney's recommendations, given that it's almost as much, 10 million, which is almost as much as the full judiciary recommended. I felt there needed to be some, I'm trying to find your, it's in yesterday's, the state's attorney's request is yesterday's documents. Annie Noonan. So I suggested that we definitely either try either the one-time or in the base a victims advocate coordinator. I thought that Mr. Lusick was very persuasive in his discussion. But in looking for somewhere, I felt that I suggested that the 12 victim advocates, as long as we have the 14 administrative support, and since these are temporary positions rather than full-time, adding to what is currently part of a grant would be extremely difficult. So I'm going to suggest that we drop that 993,600 and 1,043,280 in the second year of the request. That's the FY22-23 request. But I think if we can do it in the base, I would hope we can fund the victims advocate coordinator. On the Defender General side, I don't know if we'll fund the full base that the House has recommended, but we would recommend that the 2-year, basically 1.3 and I call it 1.4 and 1.3 million for 22 and 23 be funded in the one-time money. And then I got an awfully late request from the network against domestic violence and sexual assault. So we'll try to fit something there in the appropriations process. With the Judiciary, Judge Gerson, I know you're here, and we want to do our best to get the backlog taken care of, but again, in the 1 and 2 years, not in the, and that doesn't mean the money won't be available in a future year. Because we're not spending all of the ARPA money right now. Some is going to be set aside for future needs. But that's the kind of what for Stephanie and Senator Mitchell, of course, it needs approval by the full committee. Then on the language, Eric, did you have some language on the startup of the jury trials that Chris Maley was discussing yesterday?
I didn't have anything from anyone else. No, I think I.
No, I mean from me. Chris Maley
Right.
brought it up yesterday. I sent you.
Oh, right.
And you said yes, I can do
Yes.
something. Did you do something?
Yes, I just had a thought that I hadn't drafted it up yet, but I certainly could easily, and it's pretty straightforward. It would just be something in the, and I was understanding sort of what the committee was talking about was that an idea that that you wanted to have some of the money be used for purposes of using a 6-person juries in certain cases.
Yeah.
Was that the concept the
There would
committee
be
was
the
discussing?
intent, the committee's intent would be that that a portion of the funding be used to help start up 6-person juries, particularly in counties, as long as there's an agreement between the defense. Obviously, there has to be an agreement. In counties where they're, particularly in counties where they're not going to be able to hold trials.
Yeah, and I think you could do that with some legislative intent language. You could certainly say, and what I had written, for example, is the intent of the General Assembly that X amount of this appropriation only be spent for the use of 6-person juries as authorized by the court in the exercise of its emergency powers.
Yeah, I don't know what the amount would be. That's where the problem comes in. I don't think I could say X amount.
Oh,
Could
you say a percentage or a portion or something?
I think a portion would probably
right.
be. I would also hope that we put language in, and Robin Arnell's here, but I just don't. I talked to Michelle. That bill is very complex that the House put in a short form on it. Maxine Grad did. I think it's something that we'd have to deal with next year, but there's no reason why we couldn't put in some language requesting that, again, a portion of the funds go to help decrease the backlog in child support cases, particularly in the 3 counties that Robin cited yesterday. I think Bennington, Rutland, and Chittenden. Is that correct, Robin?
So sorry. Yes, that's correct, Senator.
I had that offline conversation with Michelle, and I don't know. It's fairly complex. We should probably do a bill for next year if that's something.
We're still going back and forth. We're seeing if there's anything, maybe some low-hanging fruit that would be much simpler.
Okay.
Yeah.
Well, this at least would identify that there is a backlog there, particularly in those 3 counties.
Senator,
did you want to comment on that?
Well, only that, I have had some discussions with Robin. The proposal has been scaled back to what appears to be a 3-county pilot. I will just tell you that we would certainly want to be heard on a bill like that moving forward, because we have some significant disagreements with the data. But I'm willing to continue to work with Robin.
I guess what I'm asking is if there's a possibility of, as we try to deal with the backlogs, that we keep child support cases in mind as some of those that need to be cleared. I'm not talking about putting in language regarding the pilot project or anything. Just, I didn't hear anything about magistrates in the presentation from the judiciary.
I'm sorry, magistrates in the what, Senator?
In the judiciary proposal, budget proposal, for ARPA money.
No, I don't think there was. We recognize that that docket, as others, has some backlog. I don't know if it's to the degree as described by Ms. Arnell, but again, we'll continue to work with them, and we recognize that those counties need some extra
right.
Resource efforts on our part.
Yeah, we know they do, and I don't know if you can use. You can hire retired judges. I don't know if there's any retired magistrates that could be brought on board.
There's 1 or 2 that we might be able to look to, and again, this issue is certainly before us. We understand that.
But I mean, from my point of view, and this is just a personal opinion, child support, the lack of child support payments impact the family adversely, particularly obviously the children. And then there is cost to the state in terms that child support needs to be made up. And so there's, it goes, it has impact throughout the system. That's all.
There's no question, and we're not trying to minimize the impact this has had. I think there are ways that OCS presently can take some administrative action without any change in the statute. So again, we're willing to continue to work with them to try to decrease the backlog.
And then one other, Senator White. Yeah.
I was just going to make a comment about when we were talking the other day, and the idea of night court came up, and I know that there was pushback from people, but it just hit me that we have been talking about how our healthcare system does not accommodate people who work. So we've asked doctors and dentists to have evening hours, maybe weekend hours, and yet our very basic right to justice, we design it around an administrative schedule. And for people who, defendants and juries who are working people, it would be very nice to be able to have court in the evening, but we've designed, so it just struck me that why don't we have flexible hours for our justice system so that people can actually access it. Anyway, it was just a thought, and I'm not sure that we should go there this right now, but I do think that we've spent a lot of time in our healthcare system trying to make sure that doctors and dentists see people when they need to. So
was your question to Judge Gerson?
No, it was just a comment, because I know that we heard from, I believe, both Terry Corsones and Judge Gerson and Matt Valerio about John Campbell about pushback around the idea of night court. And so I was just thinking, why should we just have court from 9 to 5? Anyway, just a thought.
Senator, I think it requires a lot of work with a lot of different parties to take what is an idea and turn it into reality. But
I didn't mean to do it now.
Senator Nicka, I think Senator Nicka wanted to either comment on that or
not on night court, but I'm wondering, Judge Grierson, I don't know if you told us this or not, but how many of the county courthouses are completed with work to allow them to be COVID ready?
So right now we have 9 courts. I'll quickly list them. The Windsor County Court, that's in Woodstock, has been approved for 12-person juries. Washington, the County of Washington, the State Courthouse in Barry, which is primarily a criminal docket.
Judge, could I just quickly interrupt? Senator Nitka, I think was asking, have had the work done, and I'm not sure in your list, are you saying that they've had HVAC and other work, or are you saying that as they stood with fewer people, they're okay for court?
No, these are approved for 12-person juries. These
Oh, I see.
9,
Okay.
9 courts.
9 courthouses.
9 courthouses: Lamoille, Wyndham, the State Courthouse, Orange.
Wait.
Courthouse.
I want to know if it's a county. Please, you were doing great with telling me whether it was a county court or a state courthouse.
Okay.
Washington County State Court.
Yes. In Lamoille County, of course, it's only one building.
Okay. Is that ready?
That's ready.
Okay.
Wyndham, the state courthouse ready. There actually are jury drawings scheduled in Windsor, Washington, and Wyndham courthouses now. Orange County, I indicated, is available. I expect jury trials there in June. Rutland State Courthouse, the McCaffrey Courthouse, has been approved, and I anticipate jury drawings in June. Caledonia, that's the state courthouse, has been approved, but just recently. I don't think a summons has gone out, but I would anticipate June trials there. And the Chittenden County, that's the county courthouse, primarily civil, has been approved for 6-person juries, but I'm working with the court the judge in that building, as well as the court clerk. We may be able to accommodate a 12-person jury there. I also expect Bennington, we're awaiting a final report on them, and it's possible that by next week that will be available. The Franklin, and that's a state courthouse, I'm sorry.
Yeah, Bennington, not the county.
Not the county. The county does not have, there's no HVAC. In Franklin, the state courthouse has been approved or will be approved for 6-person juries, the limitation being because of the physical size building. So we anticipate some others coming online, but you know, going back to the original, I'm sorry, Senator, does that answer your question?
Yes, thank you, Judge.
And I would just add, and I know you've got a lot in front of you, that with respect to the concept of the 6-person jury, as Chris Maley indicated, as of now, the parties have, if they agree to that, then we can accommodate that. But since this discussion started at the beginning of the session, I think we only had one courthouse available at that time, the Wyndham Courthouse, and now you can see it's been expanded to 8 or 9 courthouses. And we would expect, as we were giving a priority to the criminal docket, the priority to those in custody, but we are looking at civil cases as backup in these counties that are available. So the availability of 12-person juries, civil or criminal, is greater than it was certainly at the beginning of the session. And we will continue to explore ways of getting these civil trials going as well. But we do feel we need, take Caledonia, and I'll stop talking. Caledonia, we don't expect Newport, either courthouse in Newport will be approved. We expect Caledonia then will serve as a, call it if you want, a regional courthouse for criminal cases out of Caledonia, Essex, and Newport. And we will also have some the opportunity for civil backup. So we're looking at whatever courthouse is available to use it to its maximum.
And can I just ask one other question? So with regard to these courts, can persons from other areas which aren't open, can they be transferred to those courts that are?
They can be, Senator, and let me give you an example. The Wyndham Courthouse was ready to go in early March. We went through that list, and as that list became shorter because cases were settling, I reached out to Windsor County and Bennington County to see if they had cases that were available. And to the extent that they were going to be tried, there's authority under AO 49 for me to transfer venue for purposes of trial. So the short answer is yes, and we will continue to do that.
Okay, thank you very much.
But does that mean the jury in Wyndham County would hear a case of a Bennington County?
Yes,
So
in other
it
words,
wouldn't be moving the jury to
no, we would be relying on the county or the individuals in the county where the case is tried to be the jury.
And I believe the Bennington County State's Attorney said that she couldn't use the Wyndham Court because the Deputy State's Attorney would have to stay there in Wyndham County for the duration of the trial.
Well,
Is there something about that that's COVID related or?
it is. It is COVID related. It's setting up these courthouses is all about managing the risk. And so our plan was for Wyndham was to folks that were coming into the courthouse for the trial were going to remain in the courthouse throughout the day. We were going to make sure that the jury remained in the courthouse, provided lunch to them during the trial. And so, again, it's managing risk. And if we can
Is
limit
that still true, Judge?
it is in Wyndham. Now, some courthouses are not large enough to accommodate that. And so in some places, I'm thinking right now of Windsor County, which will be big enough to accommodate a jury, but probably during breaks, the attorneys will have to leave the courthouse because we don't have enough room for them.
Okay, so but if it was a 3-day trial, for example, Senator Benning would be gone for 3 days. He would have to stay in that courthouse or in that?
He would stay in the courthouse for the day, but
Okay.
he would obviously, at the end of the day, everyone would go home.
Okay.
But it's
Well,
the in and out, it's in and out during the day that
Oh,
we're
it's
trying to
going in and
minimize.
out during the day that.
Exactly,
It have contact with
exactly,
others and so,
exactly.
thank you, that helps. Senator White had to leave and Senator Ruth had to leave, so we're down to 3 members. But I think,
And I
don't
guess
know
I
if
just
there's any
wanted the
other-
committee to know that I think we have a greater opportunity for certainly both for criminal and civil trials now than we did at the beginning of this session.
well, a lot of things obviously will settle once you're reopened.
There's
In
nothing,
those 9 counties, the experience in Wyndham where we saw so many cases settle.
the opportunity for a trial, whether it's criminal or civil, is the best incentive to settle a case. There is no question.
Senator Benning, he's worried about having to stay in the Caledonia courthouse 24 hours.
We get a special
I
room for
may
him.
be, I may be whether I want to or not, but Judge, the way cases settle most often is when all the parties are in the courthouse, knowing they're about to draw a jury. Now we have an e-filing system. We draft a plea agreement, notice of collateral consequences, maybe a deferred sentence agreement. Are the court staff going to be instructed to accept those documents for filing? Or is there going to be a requirement on all the parties to come up with those documents before they ever arrive at the courthouse? Because that seems counterintuitive to cases settling.
The short, I think I can answer the question this way. When we stand up these courthouses for a trial and have a jury drawing date set, there will be a date, probably, I'm just going to, by way of illustration, a week before the jury drawing. That is the last day for plea agreements. If you don't have a plea agreement, there's not going to be any plea agreements accepted on the day of jury drawing like we did pre-pandemic. Those plea agreements have to be done. If not, you're going to have to enter a plea with no agreement before the court.
Well, let me just
That
make
is-
an observation because this is important. I've lived long enough in the system where we had a judge a very long time ago decide plea agreements were not going to be accepted after a given date. And the defense bar responded essentially by saying, fine, we're going to try every case. Because most often the best leverage that we all have for resolving cases is literally when we are on the doorstep of drawing the jury and we're all assembled in the same building at the same time. So I'm very, I don't want to make predictions, Judge, but I envision a problem happening if the court staff are not able to take a document on the day of jury drawing and file it in the e-filing system when people are making last minute changes in order to have things happen. understand how anybody could possibly believe we are going to reach the ability to settle cases at the same rate we used to be able to do.
I think the Defender General would like to comment, but Judge, if you want to.
I would, thank you. For the record, Defender General Matt Valerio. The e-filing rules specifically allow for the filing of documents that are drafted at the courthouse, and the court staff have to accept them. The judge may have a different rule regarding the acceptance of plea agreements, that he's going to set a deadline, or he or she, that's fine. And as Senator Benning says, that leads to other things. But I know that the electronic filing rules specifically allow for documents drafted in the courthouse to be signed, and the court staff must accept them and scan them into the system. So this was one of the very early kind of disputes that went on, and modification to the e-filing rules that occurred after the Windsor, Orange, and Windham County opening. So I don't see that as being the issue. I mean, if a judge makes an arbitrary rule about we aren't going to take any plea agreements by a certain date, well, I've seen that before too, and response has been as Senator Benning suggests, and it's anywhere that's happened, that seems to be the response. It's nothing new or magic about that. But I do know that the rules specifically allow for the acceptance of those types of documents, and so that shouldn't be an impediment, I don't think.
No, I would agree with Defender General's comments with respect to the e-filing. Of course, we can accept it from the courthouse. The issue that I was talking about is different, and I understand the controversy around it, but I've used it. I think it's an effective tool, and we would continue to use it, particularly during these COVID conditions. We're asking a jury to come in. These are not going to be our traditional jury draws. It's going to be one case, one draw, one case. And in order to conduct that trial, we're not going to have a jury under these conditions sitting around the courthouse waiting for the attorneys. There will be a trial, or there will be a plea on the day of draw.
So on voir dire day, you're saying there's only going to be one case scheduled?
Yes.
Oh, I don't know how to react to that. Is that
Well, I can tell you that, for instance, in Windham, there were approximately 10 cases that between the judge and the attorneys decided could be tried in the parameters that we're setting for these initial trials. And over the course of time, all of those cases settled. There were some that had to be continued because of witness issues. And the final case was dismissed without prejudice by the state. But they went through the entire list that they had prepared, and the majority of the cases settled. Then when we went to Windsor, they came up with a similar list of around 10 cases. Those cases either settled or had to be continued because of, again, out-of-state witness issues. Bennington only had 2 cases that they felt were appropriate. One had to be continued because of witness issues, and the other case was continued at the very last minute because of other issues relating to that individual case. So putting the notice out for jury trials, and the Windham court indicated, I think the jury draw was on a Monday, and the judge in that court said no plea agreements will be accepted the week before that. In other words, he had a date that he had set, and the attorneys knew that. So the goal is to try a case under these conditions, so that we know what it's like to bring a jury in. And that's the way we've structured it.
So I want to get back to the language before we, unless Matt had some final comment. I want to get back to the language. We've got two pieces of language that Eric is preparing for the Appropriations Committee. I just want everybody to be aware of that. They're related to the 6-person juries as well as the backlog in the child support case law. And I don't think they ordered you to do it. It's the intent. I was concerned if we ordered the court to do something, the court would say that's none of your business.
If you're asking me, I think that would be a problem if you ordered us to do that. I think Eric touched on the issue relating to separation of powers. And
Yeah.
I think you mentioned it the other day. So I think that clearly would be an issue. And that's why I was saying, I think our capacity to do trials, civil or criminal, has increased substantially since this discussion began at the beginning of the session. And I would just clarify one point I just made about one jury draw. It's a case and a backup case. We always want to have a backup case to one schedule.
One other thing that a lot of people are concerned about, that I've heard is from both sides, the landlords and the tenants, is once evictions cases can move forward, there's going to be this tremendous onslaught. Is the court prepared for that? Or will that get pushed? I mean, I've gotten letters from people who have a willing buyer for their home and they have a tenant, and the tenant won't even allow the buyer to look at the property. Things like that.
So one of the things that we're looking at, Senator, is I was contacted by legal aid, for instance, fairly recently. They may have access to funding that would assist certainly on the eviction side. So the plan is for the judges who are involved on the civil division involved in these cases to meet with their staff to set some priorities, if you will, on these cases, and hopefully get some consistency of how these cases are going to be managed when the stay is lifted. And once they have a plan in place, we're going to reach out to legal aid as well as the representative of the landlord to meet with them collectively, so that at least when the doors open, hopefully we'll have a plan in place that will
I don't know
provide some
about
direction.
the other two senators that are still with us, but I've gotten hit by a lot. And I think once the pandemic, once the evictions are allowed to go forward, we're going to be hearing from a lot of constituents on both sides of that.
So I already am also, and have been for a couple of months now, hearing from mainly landlords. I mean, many have done that I've heard from previously, even have worked with the tenant, and the landlord did their best to get money for the tenant even, and other money even. Some of them have been great. Others are wanting to get people out no matter what. I have a person who wants to move.
Just fell out.
It's like, it's all over the map, but there's a lot of the cases around. Some of them don't want to take money now because they're wanting to get the tenant out.
Right.
Because non-payment, and some of them say there's criminal activity going on, but it's not the dangerous kind of criminal activity. So, but Judge Grierson, can every lawyer or on their own file with the court with regard to an eviction? Can they at least file?
Yes, they can file.
They can file. Okay. I thought they could, but yeah. Okay.
I think many are holding back, Senator, for some of the reasons you've stated.
Yeah.
Because depending on the circumstances of a particular case, they recognize that under the current limitations, the case won't move beyond that.
Right.
Alice, you were talking, I don't know if you heard, but Dick had a family situation and has left the screen.
Oh, no, I didn't hear that.
But you're the ranking member at this point, so.
Okay. Anything else, Judge Grierson or Matt?
Can I ask a question? I think I might have missed this because I was coming in from another committee. The 6-person jury is not intended for criminal cases, as I understand it, correct?
No, not as far as I know.
All right, that was,
No.
I didn't think it would be or could be, but I just wanted to confirm. Thank you.
No, that was civil matters.
Right, okay.
Yeah.
Anything else? What time is it?
Dick, you're muted.
I'm sorry. Thank you, Alice, for handling it.
You're welcome.